Hey guys, we're going to be talking about demand letters in the PIP statute. For those of you who don't know, before January 1st, 2003, every single PIP case was an automatic lawsuit. There was no demand letter requirement before January 2003. An attorney would go into a doctor's office, get all their PIP files, send lawsuits on everything, and get attorney's fees or not, depending on whether it was a winner or loser. At that point, there was no demand letter requirement. So, in 2003, this became the law, a conditioned precedent to filing a lawsuit. You must have written notice of intent to litigate, must be provided to the insurance company. They specify how to give them that notice here. It says the notice must say demand letter under section 627.736 and must state the name of the insured, including the AOB, the copy of the AOB if applicable, the claim number or the policy number, the name of the medical provider who rendered treatment, with the itemized statement showing the exact amount, date of service, and type of benefit sought, type of benefit, CPT code, what was the type of benefit sought. If the demand letter is being sent because of an IME, independent medical exam, you have to attach the IME report, but wait, there's a twist. Courts have said, listen, the insurance company made the IME, they have a copy of the IME, it's not necessary, they know why they're denying it, so they don't have to, the plaintiff does not have to get a copy of it in order to file suit. It's kind of like, hey, I can't file this lawsuit, I can't send this demand letter because I don't have it. That's not fair. So the insurance companies, that's kind of, you could just delete that, but it is in the statute. You have to send the demand letter by USPS certified or registered return receipt. That's that green card on the back. I just send it certified with the tracking number. Postage costs are reimbursed if the PIP claim is paid in response to demand letter. And you have to send to the contact person and address that's listed on FLOIR.com, FLOIR, F-L-O-I-R, Florida Office Insurance Regulation. They have a database on the website that you can access for free. It's there. For each insurance company that sells PIP in Florida, they have a contact person for PIP. That's where you send it to. Now, if a demand is, if they pay in response to a demand letter, okay, so I send a demand letter and they pay that day or the following day, they got to pay me a 10% penalty up to $250. So if they decide, if they owe and they pay correctly $200, they have to pay 10% of that. That would be $20. If they owe and pay $2,000, then they got to pay 10%, $200. Now, if it's $3,000 that they owe and they pay $3,000, it's capped at $250. It would not be $300. It would be $250. It's capped at 10% up to $250. Now, if they don't pay and I file a lawsuit and they're like, okay, Abe, you caught us this time, man. You got us. We owe you money. They do not have to pay the penalty. They only have to pay the benefits, the interest, and the attorney's fees. That's it. This statute reminds the insurance company about the interest and then the 10% penalty. I didn't write interest up here, but it is in the statute. And then the statute of limitations is told, meaning it's paused for a period of 30 days when you mail the letter, the demand letter. Because they have this conditioned precedent requirement before filing a lawsuit, they have to give you an extra 30 days on the statute of limitations. I mean, you have 5 years to do PIP demand. We'll talk specifically about that and give you examples in another video, but you get an extra 30 days from the 5 years. If you're waiting that long to do a PIP demand, you got bigger problems. Now, there's one other thing I want to talk about here, okay? And it is, for purposes of this section, payment or the insurer's agreement to pay shall be treated as being made on the date a draft or valid instrument is made. So that's the date of a check, the issue date on a check when it was printed, or the insurer's written statement that they're going to pay. So, hey, I'm going to pay you. The check takes some time, but we're going to pay you. Or the insurance company's written statement of agreement is placed in the mail in a properly addressed post-paid envelope. Or if there's no date on the stamp, the date of delivery. I've never seen an insurance company say, hey, we're going to pay you. They always pay. So it is, most 9 times out of 10, it's going to be the issue date of the check is the date that we would file suit. And I'd imagine if they sent the letter saying, hey, we're going to pay you, and they took too long to pay, I think they could get in trouble for that. We'd probably sue them too, but I've never really seen that. So thanks for tuning in on Demand Letters. Thanks for watching.